Awesome.
Don't fall asleep, Trevor.
For those of you who own rentals, who work with landlord clients, or manage tenant-occupied properties, what you're about to hear will save you some serious money, some serious heartache, and some serious therapy later down the road. Our guest speaker tonight has spent 17 years advising landlords, investors, property owners on eviction strategy, compliance, and risk management between Oregon and Washington. He is our real estate attorney, and he is known for his prevention-focused approach, helping his clients, us, avoid costly mistakes before a dispute ever escalates. From Phed Law, please welcome Mr. Robert Phed.
Glad we had a little break, so let's raise a toast to all of you because you're here, you're successful to your success.
Let's go.
Yes. I was perusing the nice brochure here. One of the reasons to use Uptown Properties is, are you tired of the 3 T's, toilets, tenants, and troubles? And it's like,
Where they targeted.
you're right. You know, they say the owning property is great. It's the only business where people call you at midnight to tell that your toilet has emotional problems. So, you know, sometimes that's what it is. And some other person said that as a landlord, you get to fix problems in properties you don't live in. At times you did not even know existed, caused by things that you did not break. So congratulations, that's why you're here. Couple minutes about myself so you know what we're talking about here so that I'm not just coming off the street. I have had the privilege of working with a lot of landlords and property management companies for about 20 years now, specifically landlord-only side since 2008. So this time has been, and the reason why this actually presentation came to be is because the need for a general overview and kind of a fixing things here and there and explaining things has become quite great. A lot of property managers and a lot of owners want to hear what the story is, how things happened, how things changed, and also I'm sure everybody heard a lot of horror stories about how things go sideways. And this is what we're trying to do. The point here is that as a result of this presentation, hopefully you will save yourself a lot of attorney's fees that could have been awarded if you lost an eviction for the other party, or you save yourself trouble and headache and also money by triaging an eviction that was going down the drain and now you can save it. So that's what I typically do. I do Washington and Oregon, but this one is only Oregon. So we want to make sure that this is specifically just to what is happening here and what happens in Oregon only. As you may know, the 3 counties that we mainly work here is about as different as anything you can imagine. Even though the courts say that this is a unified court system, it is anything but. It is about as different as like if you've heard the stories of the medieval knights, they go from one kingdom to the other. This is about how it feels when you cross in from Washington County to Multnomah County to Clackamas County. It cannot be more different. And why I'm saying that is that even though the laws are technically the same, how they are applied and what happens every time you go into court with an eviction is what makes or breaks your approach and what makes or breaks your budget. So we're going to talk about that in just a bit. So why do we have this topic? It's because a lot of times prevention is great, but what happens is a lot of times a lot of people get themselves in situations where they don't know how to come out of a problem, or they have a problem in their hands that they created themselves. And we're trying to make sure that this is not going to happen after we're done with our presentation today. So you are aware of, so to speak, trigger points, things to look at for, things to fix, and then how to develop certain systems as opposed to goals where you can achieve your results. Because this is a 1-hour credit for CLE, for continuing education, I have to put some law later on because they would not give that credit if I don't, so that is what it's going to be for. Why are we trying to explain also what this is not? is because we're not trying to solve everybody's problems today. I want to make sure that you understand that this is not a free attorney consultation. This is just a general overview of what's happening. And that's why we're not doing any tenant advocacy. I'm only talking about a landlord side, period. And then we're not doing any legal theory either, because there are many ways that a lot of attorneys have discussions. Even some laws that people think are simple can be misinterpreted or interpreted different ways, and this is what attorneys do. They argue, they talk. So we're going to not get into that. We're just going to go in a very normal way. And then city by city compliance, of course, this is not. You can have an hour and a half to 2 hours on Portland alone with all the different stories, but if you do own properties in Portland, my apologies. This is not something that is going to come easy for you. How many of you are actual investors versus realtors? Do we have investors? Okay. And realtors? Okay. And then you own your properties too? Okay. Fantastic. So this is going to be good. So one thing that they want us to put on is when you get to the realtor part, I want to make sure that a lot of people feel comfortable with this approach of a counselor, because RS 696-810 3E, one of the affirmative duties of the buyer's agent, which also matches one of the affirmative duties of the seller's agent, is to advise the buyer to seek expert advice on matters related to the transaction that are beyond the agent's expertise. So, a couple of horror stories right away. I got a call from a potential client who had put an offer on a house. It was a duplex, and very nice property, like mentioned, potential for good return. However, the listing agent neglected to check one side of the duplex that was rented out. They never went there, so this was posted without any checking of the duplex for the renter side. Well, so what happens when the inspection came in? The buyer walks and finds out that there is a relative who is living in the basement that does not have an exit, that has no windows, so no egress at all, and it is not not even suitable for living space at all. But there is a bed, there is his dresser, and everything else. And so the question they had for me was, well, what do I do about it? And I said, well, you can do a lot of things about that. Depends upon what you want, if you want to deal so much or not. And we went over some situations, but the main issue here was that they didn't do the due diligence. You could not give advice, or you could not give help to your client if you didn't even go look. And if this was a situation where you wanted to get an attorney involved, then the seller could have gotten the person out. There are plenty of notices that we can do to get that in compliance. And then you have a much more marketable property that you don't have to have people who are maybe newbie investors who have not done it before. They're afraid to buy with a renter. And especially when there's a renter who they will have to immediately start doing notices and evictions. So that's one story number one. Next story number two. Oftentimes you want to close the deal so much that you forget that maybe best advice is to walk away. And we had a situation where the tenant who was on the property that is being sold promised, swore to God, that he's going to move out at a certain date before closing. Guess what happened?
He did. He moved out.
You got it. So the moral of the story here again is that if you are in a position where you can advise your client, this is sometimes best thing for you to do is, if you have a problem with the tenant, or if there is a tenant and you want to do something different, how about talk to an attorney or find out the way to fix it before it becomes a problem. Of course, the deal fell apart because the tenant was still there and nobody wanted to do it. A success story though. We had a situation in Clackamas County where we were in the process of evicting a tenant. The property at that time was being sold, and the sale actually happened while we were still getting the judgment. Because the realtors worked together, we were able to transfer the judgment from the seller to the buyer. And they were able to successfully finish the process and get the sheriff's lookout scheduled and got the tenant out. So that is one of the better examples of how you approach the situation when there's a problem. You simply work together to make it happen, and you're not afraid to face the problem. Because oftentimes people think, well, if it's too much, what do I do? Is it going to be fall apart? Yes, it probably will, but if it doesn't, you have just delivered an extra added value to your client in a sense that they feel like you're comfortable doing it. All right. All right, let's talk a little bit about what is happening with Oregon and why Oregon is different. Oftentimes, a lot of people come from California. They come from, somebody from Oklahoma, and they say, but this is how we do it there. If you hear that, run. Because this is not something you would want to ever hear. Forget about how you did it. Or if you're an employer, you have somebody come in and say, well, this is my old firm, we did it this way. Again, not a good idea. Oregon is very different. It is a very highly procedural system because everything is quick. So the point of it is the legislature in their infinite wisdom thinks, we're going to give you an opportunity to get the tenant out quickly, but you have to play by our rules. And we're going to set up the rules in a way that makes it a little bit difficult, but not impossible to get the tenant out. So that's why Oregon in this sense is extremely different than anybody else. I mean, we're not talking about Florida. Florida, from last thing I heard there, is basically, you know, they come in with a gun and take you out of there, and it's about 2.5 minutes, and that's about it. But we're not there yet.
Perfect.
Yes. Technical compliance. Oregon is very particular about technical compliance. This is something we're going to get over this in just a little bit later on, is you have to understand that it is not optional. If it says you have to do it this way, that's what you do. And a lot of times people come to me and say, well, but I substantially complied. It kind of does say it in my notice. Well, I'm sorry to tell you, but the legislature thinks that if you didn't do the notice right, you cannot go from here to next step. So if you cannot do that, then I'm going to tell you the bad news. You have to redo your notice. So this is something that a lot of investors or people who are just coming into this, or even those who have a property management company but don't understand how it works, it always is beneficial to know that, why this is important. And of course, the judges enforce statutes strictly. Yes, and why is it important too is because each county has its own different nuance. And every county, unless you know how it operates, can cause you to lose a lot of money. We'll just talked a little bit before about what Washington County does. If you are not quick enough to pick up a trial date after you have had the first appearance, you may be looking at a trial date here or 4 months down the road. At about $2,000 in rent per month, what difference does it make? That makes a big difference because somebody ran to the clerk faster than somebody who came in a little bit later. And that is the difference. If you don't know that, you are out $8,000 just by pure nature of not knowing how the process works in one county or the other. If you live in Clackamas County and you have properties there, bless your heart. You're going to be out of there. It is going to be by statute within 15 to 30 days, and you're going to get your trial within that period of time, and it's going to be wonderful. If you're in Multnomah, it's a toss-up. So, but this is a kind of a situation where you do need to figure out all the nuances and understand that that is what's important. So 3 layers, the TRIP landlords. Simple, state landlord-tenant law, local overlays, and court practice. So let's go through that line by line. So what we have here is this. Let's just quickly overview the process of what is exactly happening with the evictions. Evictions start with a notice. And that is one thing that you absolutely need to understand is that nothing happens unless the notice goes out. You don't have to file on the notice, you don't have to do anything after that, but you cannot start the process of eviction without doing a notice. Notices for cause, notices for no cause, notices for non-payment of rent, whatever it is, but the notice is your starting point from anything you want to do with eviction, that is where it happens. Then you go. After the notice expires, and I will use it loosely, the word expires. Expires means that the termination date on the notice is, say, for example, the end of the month. And if the notice expires on the 31st of May, you cannot file an eviction before the 31st of May. On the 31st of May, nothing happens, tenant still stays there, you file an eviction on the 1st of June. After that point, the eviction gets scheduled, you get the summons and complaint, and the eviction gets scheduled for what is known as a first appearance. And again, because different counties varies, this is where you're going to have a lot of fun. So you have an unpaying tenant, you have a tenant who is costing you $2,000 a month. If you are in Clackamas, you'll be there within a statutory period of time. If you are in Multnomah County, if the clerk feels good that day, and if other people did not file a lot of cases that morning, you may get a hearing within maybe 3 to 4 weeks. If you came in at 4 p.m. to try to file, and Action Services or Landlord Solutions has filed a bunch of cases that day, you're looking at 6 weeks. So that is just what happens. And if you're in Washington County, again, so help you God. So what happens during the first appearance? What is that? It actually is what it is. It's the first time everybody appears to court. And this is the time when you have a chance to resolve the case with a tenant. Are they successful? Yes. Oftentimes courts provide you with the paperwork where you can fill in. It's called the agreement. And it basically says, whatever you want to decide. You want to agree for a move-out date, you want to agree for a payment plan, it is what it is. What's important to know is that those agreements become court orders. It's not optional after that point for the tenant not to do what he promises or she promises to do. It is a court order that is enforceable by a judgment if they don't do it. Oftentimes, a resolution cannot be had. So you have a chance to talk, you talk, nothing happens. You have a tenant who's too recalcitrant and nobody wants to do anything. Sometimes tenants develop what I call a tunnel vision, where even though you offer them options and ways, off-ramps, they just don't want to take it because they either want to be too proud or they don't know how to do it, but you end up in a trial. So what happens then is, the trial is the time when everybody comes together and one party wins, one party loses. There is no draw. It's not 1-1 like you get in soccer or any other game. It is 1-0, that's it. One wins, one loses. And this is, again, what are we doing here is court practice. Court practice differs. Some counties schedule these trials within a statutory period of time, some don't. So just make sure that you understand that when you are talking even to your property management company and they come back and say, your next first appearance of your trial is 4 months from now, don't have a heart attack, because now you know that's how it happens. It's not that they did not do something right for you, it is just how it is. So what happens if you go to trial and if you win? Then you get a judgment. The judgment purely says that you have possession of the premises. And one thing you need to know is, remember, in Oregon, unlike Washington State, which is again just across the river, but it's a whole different world, you cannot get money award for rent as a part of your eviction process. Evictions in Oregon are only about possession. It is who has the right to premises, you or the tenant. That's it. You can start with maybe non-payment of rent, but the end result is only possession. That's all we have. And after you get your judgment, you have another step, another hurdle to go over. That is not just the sheriff comes over to lock you out right away, the tenant out, you still have a notice of restitution. It's what the legislature thought would be a good idea to give tenants yet more time. So then, before they are technically out, you still have another 4 days, that's if they issue it right away, and it may take up to a week to even get that notice issued before the tenant has to move out. Of course, they don't do that, but then after that, you still have yet another hurdle. You get what's known as writs, and writs are basically like the old days. They are a mandate to the sheriff by the court to go and physically remove the tenant out. And only at that point is the tenant out. So this is your overall overview of the process in a nutshell. And if So this helps you understand that when you are talking to your property management company or you're actually dealing with this by yourselves, you know what you're looking at.
Robert, can you break it down just real quick? So you've got your notice.
Yes.
And
Notice.
that's for, let's say, non-payment. That's a 14-day notice. You file for eviction on the 23rd.
Yeah, we're going to go there too, yes.
Oh, this is coming up?
Well, there will be some of it, yes.
Alright.
But go ahead, ask a question.
But then you've got your first appearance.
Yes.
That's supposed to happen within 14 to 30 days.
Well, yeah, nobody cares.
And then you have a trial.
Yes.
Which is supposed to happen in 30 days.
Yes, correct.
So now you're 2 months.
Yes.
And then you have your
I see what you're getting at.
and then you have your.
All right, so let's be county specific because this is going to be a difference between the counties. Clackamas, you're right on the dot. You're 15 days out. You're 30 days for your trial, and then they issue your notice of restitution right away. It's another week. Then the sheriffs there are about 4 weeks out, 3 to 4 weeks. So you're looking, if you're in Clackamas County, from the notice period, if let's just do a 30-day notice, just for ease, yeah. So you're 30 days, you're 1 month, another 2 weeks, another 2 weeks on top of that, maybe another month. So you're looking at about 3 to 4 months total in Clackamas to get from the moment
Best case scenario.
Best case scenario, right? The moment you issue the notice to the moment you get the keys for the possession from the sheriff. If you are in Multnomah County, add another 2 months. If you're in Washington County, that all depends upon how fast you run. Because if you, I'm not kidding. If you run quickly during the first appearance and you can get your matter resolved right away, you know you want to do the trial, then you run quickly, you get an earlier trial date. If you're late, you're going to get a trial date 4 months later. So Washington County, I always tell people, is between 4 to 6 months. So what happens there, I have had plenty of trials that were in September on a December notice. So people come to trial with $20,000 worth of back balance. There's no way. And the reason for that is because the legislature thinks that maybe somehow delaying an eviction process helps the tenant. No, it just buries them deeply into debt. And that's all there is to it. But those are the timelines you're looking for.
Good question.
Yes.
Have those timelines increased over the past 4 years?
They have increased last year. So yes, basically what, don't quote me on this because I don't know the innards of Salem, but somehow something changed there in the last year and a half where counties became more, courts in the counties became a lot more belligerent in terms of how they manage the flow. And so I'm sure the excuse always is we don't have the resources, so this is all we can do. But the statute is the statute. The statute says the use of the word shall, meaning that you shall set the trial within 30 days. They don't do that. So this enforcement of the law has become very, again, wishy-washy because they don't care and there's nobody who is going to spend money to go take them to court to force them to do it. So this is basically what you have to deal with is the legislature, from my standpoint, thinks that every one of you is evil and every tenant is an angel. And because you are evil by definition, you have to be, it's okay if you suffer a little bit longer.
Yeah.
So if you are evil and it takes you an extra 4 months because you're not fast enough to run to get a trial date because they cannot, get their act together and give certain trial dates in a normal environment or a normal amount of time, tough. And that's kind of where it's coming from. So the changes happened within about the last year. Before, it was pretty much strictly by the statute. This has been very discombobulated. Yeah.
Isn't there, counties that there's a statute statewide?
Yeah.
They're supposed to provide
Yes.
by the deadline.
Yes.
They don't, they do their own thing.
Yes.
Is there an opportunity for a class action lawsuit or something?
I'm sure there is, but I have never seen a landlord who wants to spend $15,000, $20,000, $30,000 trying to prove a point, which, because of the expedited nature of the proceeding, would kind of be moot. Because you are looking into 2 to 3 years to go through the Court of Appeals on that matter. So it's dollars and cents. Let's look at the actual example. So here we are. We're looking at things that trip landlords and how you lose your eviction before you even start. In an eviction for non-payment of rent, when you send out your 10-day notice, which is now 10 days, please do not ever use 72-hour notices. They are rest in peace and gone. This is what happened. This is why I'm saying that things have changed in how the legislature is doing their business. This is a notice from before September 2025. Okay. This is a notice from September 25 to December 2025. Anybody cares to tell me what the difference is? The only difference is this little paragraph right here that says if you have a child under 1 year old, you have certain rights. The problem with that is that if you filed your case on September 1st of 2025 and you used this form, you're done. It's over before it even started. So knowing that helps you to not do that to yourself. And, of course, the legislature was not done. Literally on December 30th, I think it was whatever that's Saturday, or the Friday before the 1st, they came up with an email and shot everybody an email saying, oh, and by the way, effective on the 1st of January, we have a totally new notice. And this notice now is going to be this way, and if you file an eviction without this notice in this form, you're done.
Did they give us 10 days notice about that?
That is very funny. I'm going to use that next time. Of course they didn't. Like I said, it was pretty much on the spot. So there was a frantic activity. Everybody's sending each other emails saying, did you know? So that's kind of where we are at right now. And this is one of those things that will trip you. Okay. So let's also talk about where all of this beauty rests. You have, to make matters even more complicated, the legislature decided that they're going to give eviction statutes in two different spaces. One is Chapter 90, ORS Chapter 90, Oregon Revised Statutes, and the other one is Oregon Revised Statutes 105. Now 105 deals with other things too, so evictions are like in the middle there. And Chapter 90 also deals with kind of like, how do we do this? And Chapter 105 is, what do we do? So 90 is what you shall and shall not. This is your 10 commandments, basically, for your landlord-tenant relationships. And Chapter 105 is, well, how do you go about it? If everything comes to, push comes to shove, what do I do to get them out? And that's kind of one of the things to also consider when you're working with that. So then remember also the city of Portland. That is a wonderful thing that I'm not even going to touch today, but I just want to make sure that you do realize that if you have a property in the city of Portland, there are many other requirements that you need to comply with. And this is when we had a discussion here is, well, how do you interpret a statute? Well, some people interpret a statute that there's one form there that it says there that you have to send that form with any notice of termination, even if it doesn't apply. And that form talks about the relocation payments. So why would I need to send that form if I'm terminating the tenancy for conduct? But it says that, and a lot of people don't use it, but some attorneys claim, I am on that side too, that if it says that you shall use it, it's easier to just add a couple more pages to your notice than have to then fight with somebody else who has a different opinion on the other side. Like for example, the city of Milwaukee, they're, thank God, not as onerous, but they also have a new requirement. They have a 90-day instead of the 60s or whatever it is, but there is no relocation assistance. So that is another overlay that you would be looking at if you were to consider doing work. And then again, remember, whichever property you have in whichever county would be very county specific. Because for example, Milwaukee, all it does in their section is does not require relocation and very limited. While in the city of Portland, there is a whole intersection of 3001.05, and there is a whole slew of things. And for example, one thing there about that relocation assistance, we're talking about tripping things. How do you define a bedroom? Oftentimes people say, well, that's very easy. A bedroom is a bedroom. This is where there's a closet. Well, apparently closets are not required for a bedroom. And the city of Portland, in their other parts, describes a bedroom as a very limited situation. You have to have access outside, inside. You have to have a window, but the space should be, not as big. But there's nothing about the closet. And a lot of times I've had discussions where people say, well, I have this space that could be used as a bedroom. It's just like a walk-through. So it's kind of like everybody uses it maybe as a sitting area. But if you were to put a bed there, it becomes a bedroom. So did you want to send a notice with payment for a 3-bedroom house, 2-bedroom house, or a 1-bedroom house? And so that is kind of one of those things that we all have to grapple with and decide what are we going to do and whether it's worth it or not, that extra $200 difference for you to fight this over later or not. Obviously, if there's requirements that are not met, that's a different story, but we are where we are. Another thing is I want to make sure that we understand is this. Anytime you try to use old forms or old methods that you have been using, please reconsider that. It is very important for you as people involved in real estate to realize that whatever happened even 6 months before may not necessarily be what is happening today. This would be just your one example right there, how things changed even in 4 months. And you went from winnable case to completely lost case, even if you missed that, switch over, just like that. And this is something to consider. And every time you hear, like you're working with an investor or you're working with somebody else, and they keep on telling you, well, I haven't had an eviction in 20 years, and I know how it is. I'm a wonderful person. Well, yes and no. I mean, congratulations that you haven't had an eviction in all this time, but what happens is then it ends up costing you $5,000 to $6,000, and they're all upset about it. And then I say, well, then you divide that by 20 years that you didn't have an eviction. So your expense basically is, $500 a year on costs of the eviction. So it kind of, evens out. But if you're trying to come into this business by thinking, I know what to do because I've done it for 20 years successfully and I've never had a problem, it may not be a good idea. So remember what happened in the past. In the past, we had 72-hour notices. And before COVID, and I always use this as pretty much a benchmark. Before then, courts were very quick, and landlords did have a lot of sway and say. So you do your 72-hour notice. That notice required you to require a tenant to make a payment. And if they did not, you do not have an obligation to take any money from them. That's it. Moving on, get your court date, get somebody out. You can get a full entire eviction completed from the beginning to the end within about a month and a half to about 2 months at worst. Now we have a 10-day notice, which requires you to take a payment from the tenant in the amount that is either equal to or higher than is on the notice, all the way up to the judgment entry. So you can go to trial, and you can have a judge speaking, and if the tenant were to give you say the notice amount is for $1,000. If the tenant at that time gives you $1,000, guess what? It's game over. The tenant wins. You are done. Case gets dismissed. You take the money. Let's think about what happens in Washington County, shall we? We are now 6 months from the first notice that was issued. And you issued your 10-day notice for 1 month of rent, and you're all happy. You think, yay, I got them. And then it's for $2,000, and now they had 6 months together, $2,000. They delay as much as they possibly can, and then you go to trial, all ready to go, and then they give you the check for $2,000. Game over. So that is something that the landlords have to keep in mind when you are going forward in this world that is changing rapidly. So whatever happened before COVID, that is long gone, forget about it. What happened during COVID is a lot of times people would get special protections for eviction if they were working with an eviction agency or if they were working with a rent assistance. So that rent assistance has paid a lot of you. And it's great, but it's your and my money, because we pay in Texas what you're getting paid through the state. Because all the funds gets distributed is from either the federal government or from the state, and it is what it is. But what happens now is a lot of the funds are drying up, and when they used to be able to stop the eviction process just by applying for funds, now that is not the case. So you actually do have to have somebody actually deliver money to you, otherwise you can still continue the eviction. So, what happens? Let's talk about problems and how they occur and what are the trigger points. On your day one, this is when things start to go south. Your late rent, lease violations, access issues, or complaints. Late rent, obviously there's not much to talk about here. I would also always encourage people not to ever let tenants not pay rent for a while. I have seen landlords who do not take any action for years. And if you can afford that financially, bless you. I mean, you're rich, fantastic, but that's not the way to run a business for somebody. You should not be letting that happen. Lease violations. So what happens when the tenants go bad is things start to happen. And how much of it do you tolerate? You shouldn't. If the lease violation happens, send out a notice. Either you do it by yourself or you have the notice issued by an attorney, it doesn't matter, but you need to take action. Things need to happen. And if you don't do that, if you let it sit and basically stew in its own problems, then you're not going forward. You're not going anywhere. All that happens is it just makes it worse and worse and worse. Access issues. So what happens is a lot of times I hear this, the tenant decides to change the locks. And they don't give you the keys. You have no way to get in there. So what do? You do nothing. Well, that is going to be a problem because you as a landlord are required to take care of the property. How are you going to go take care of the property if you can't get in? They can deny you access, and then you're just going to sit there and tell your owners, well, I'm sorry, I can't go in there because they changed the locks. No, do the notice. There's a way to do it. There's a process to do it. But don't let that slide because this is when this is going to start going south. And then complaints. I would characterize complaints as the ones that are valid and the ones that are there to draw attention away from the fact that they're not going to pay rent. And when that happens, this is where the minefield is very easy to go on and have a problem there. So you need to be careful about that. Make sure that whatever complaints you receive, you respond to them, you deal with them, don't let them simmer, and then again, make sure that it is all documented. My biggest thing is for all of you, remember also, whenever you have any communications with the tenants, always respond to them. Don't assume that you are just going to start doing something. If they ask a question and the answer is no, say that. Because if they can come back to you and then they say, well, you didn't respond, I thought it was all okay. So something like, can I pay rent 10 days later? The answer is no. Say it. Because then 10 days later, they're going to come back and say, well, here's the rent. You're going to say, I'm not going to take it. I'm going to issue you a notice. They may win in court because you did not respond, and they reasonably could think that you agreed to the 10-day extension. So these are the things that you have to keep in mind. Remember, you're evil, they're perfect. So whatever they say, unfortunately, wins in court. So a lot of times courts look at that with the eye that is most beneficial to the tenant. So if it's, yeah, maybe here and there, you're not going to win on that one. So here's an example. So, hey Marcus, I noticed February rent wasn't fully paid this month. Everything okay? No, I paid the full rent. If I'm paying $1,300 monthly divided by 31 days and then multiplied by 28 days in February, we're at 1174.19. Simple math, you're done. That's the example of what you're dealing with. Okay, another fatal mistake, over-communicating. This is where a lot of landlords or representatives get themselves tricked. Every time you write something, remember, you're not there to write an emotional thing. Everything you write will be used against you in a court of law. meaning that everything you have, all the emails that you send, all the texts will be used as an exhibit because the tenants can, and it is your own statement in communication with them. So please don't go too crazy with the emotional email. You can sync your eviction, like I said, when you are not responding properly or when you're going too overly emotional. And what I've seen is a lot of times landlords go crazy and like, well, I've given you this, I've given you that. Who cares? It's a business. All you need to do is state what you want to do. I do recommend, if you have trouble with writing emails, just use ChatGPT or whatever any other AI. Run it through them and through that system and make sure that it is very neutral. You're trying to convey a message. That is what you're trying to do. We're not talking about lectures. You're not their priests. You're not there to take their confession. All you're trying to do is deliver a message, receive a message back. Inconsistent demands. Please make sure that what you're asking them to do is consistent. You cannot say, well, I'm going to give you 10 days to pay 10 additional days to pay rent, but then 5 days later demand the rent be paid today because you changed your mind or because your owner says, what the heck are you doing? So make sure that everything that you do has a consistency to it that is, you can track it. And then written admissions. That is where a lot of people get tripped is this. Did we have a change in the rental terms? The tenant says, the rental agreement says the rent is $1,000 a month. The tenant comes and says, no, the rent is $800 a month because he told me that I can take the $200 off because I'm doing the lawn mowing. You say, no, that never happened. And yet somehow from 2 years ago, tenant produces a text message exchange where that exactly says that. That says, hey, Johnny, would you like to take $200 off of rent if you do some lawn mowing for me? And that's it. If you filed an eviction based on the fact that they have not paid that full amount of rent and you have that text message as a written admission that you have reduced your rent, you're done. All right, let's talk about the notices themselves. This is something that a lot of people need to understand. So whether you're going to do this by yourself or if you're going to use an attorney or if you're going to go use a service that prepares notices, or even if you do notice searches like for multifamily or for RHA or some other companies, make sure that the notices are most current. If you're using them, even if you have used and if you have in your database a notice that is from, say, July of 2025, don't rely on that. Please double check to make sure that that notice is the most current version of it, because if you don't do that, you may get in trouble because it may be outdated. All termination notices need to be separate. Do not put a 10-day notice for non-payment of rent with a 30-day notice for cause, because that is silly. We're going to get into this just a little bit, but they need to be separate. I understand that you all think that maybe I can just do it quickly and more efficient, but please don't do that. You must have your required time and date of compliance. If you don't, that is going to be a problem. For some time, we had a situation where we had an end of day midnight language in our notices that was okay until in about September-ish, the Court of Appeals, in their infinite wisdom, decided that every tenant in the state of Oregon does not understand what the word midnight, end of day, means. So apparently that was a difficult thing. So now everything has to be 11:59 p.m. So if you do not have the 11:59 p.m. on your notices, both termination for cure dates and the notice of termination and the actual termination of the rental agreement itself, you're going to have trouble. And then no cause terminations used when not legally available. Again, this is something for folks, especially in the city of Portland. You have to be extremely careful. There are only 4 or 5 different ways of issuing a no-cause termination notice nowadays for qualifying landlord reasons, basically, and there are other myriad of things, like if it's under 1 year contract or over, but you need to be aware of that if you issue a notice of termination that is not allowed, there will be trouble. All right, let's take a look at this wonderful beauty. So this is an actual real notice that was sent by a real estate agent who was trying to help a person sell a house. The person who is trying to sell a house is from California, so they're not even here. The person who is trying to help them is the agent, and this beauty came out. 24-hour notice of termination for drug-related activity. 10-day notice to pay rent or vacate, which is something that is used terminology in the Washington State, not here. 30-day notice of termination for cause for unauthorized subleasing. All at once. No dates, no termination dates, no termination times. This is an actual real notice that was produced. This is an example for you what not to do. Number 3, service errors. Because the process is extremely specific to what the statute says, the statute allows service in certain methods. Service is where things get tripped. A lot of times people think this. If it says that I'm doing a personal service and somebody is behind that door, if I'm going to come here and I'm going to shove this notice under the door, I personally served somebody. No, you didn't. So if personal service means I'm coming to you and I'm giving you the paperwork. That's what it means. That's it. Then there's another methods of service. Say, for example, you are trying to do the post and mail. Well, knock on the door first. Maybe they're there. You know, see, maybe you can do personal service, but post and mail is fine too. But post and mail only works if your rental agreement so provides. And oftentimes in the rental agreements, I see mistakes where people don't put the, I'll get specific here. So it's Oregon ORS 90155, service of written notices. Posting must be done in a secure manner on the main entrance, and only if your rental agreement permits you to do so, but has to have listed landlord's designated location, which shall be described with particularity in the written rental agreement, reasonably located in relation to the tenant, and available at all hours. So, if your rental agreement says that you can be served notices in Salem, and your property is here, you're not going to be able to do post and mail. So that's one thing that you need to be aware of. It has to be reasonably accessible. If it is on the same TriMet bus line that people can get there, okay, that's fine, even if it's in the other part of town, in Tri-County area. But again, all of this is something you need to be careful with because this will trip you up. And then the other thing about the service of notices is first-class mail. First-class mail is what it means. And I beg of you all, please learn how to count to 3. Because you have to add 3 extra days to your service by mail, to your termination notice, cure dates, and the actual termination dates on the notices. If you don't do that and you serve by mail, you will fail. And this is one of the things, how things go south even before you even get to court. Remember to count to 3. It's very important. Oftentimes I recommend people using on PCs, they have the little calculator. When you open it up, click on it, it gives you a date calculation option. And you can add or subtract dates. Just use that if you don't know how to count that. It is always helpful to overcompensate and double check than miss it out on 1 day or 2 days. Certified mail versus first-class mail. I cannot tell you the stories that I'm hearing about people going to the post office, trying to serve a notice by mail, and the friendly postal service person says, well, that's an important document there, right? Well, yeah, that's a notice of termination. I'm going to try to kick them out. Well, don't you want to know that they actually got it? Well, yeah, sure. Well, the only way to do it is with some tracking, and tracking is certified mail or priority mail. No, just say no. Remember the good word, no. I do not need that. It has to be first-class mail only. And until the statute is changed, just please do that, because you will get yourself in trouble and mess it up if you don't do it. And again, the good old, they got it. They got it doesn't mean legal service. Some people just send it by email. No, you have to, by email service, you have to have a whole entire different set of things that have to happen after you enter into a rental agreement to make that effective service. So just because you think, hey, I already gave it to him, they know, if it is not an approved method, you're out of luck. Next one, improper rent payment application. This is something to be careful with, and I always ask people to always double check their ledgers and make sure you understand what a ledger is. The ledger is your friend. The ledger is your is basically a thing, you cannot go anywhere without a ledger if it is for non-payment of rent. Even if you're doing a notice of termination for non-payment of rent for several months, and you can do some partial payments in there, you still need to know what it is. So it is very important for you to remember how to do that. Oftentimes, payments are applied to the wrong months or different charge. Fees or on utilities were credited before rent, which you cannot do. Partial payments were misapplied or partial payments were put on 10-day notices. You cannot do that. Or non-payment amount becomes inaccurate because you forgot to apply a credit and now you have overstated the amount of rent. So, sidebar here. 10-day notices are extremely unforgiving. 30-day notices are extremely forgiving. So long as the amount requested equals what you have on the ledger. So if you make a mistake and put a lesser amount on your 30-day notice, who cares? If you make a mistake on your 10-day notice and put even 1 penny more than you are entitled to for that 1 month of rent without any partial payments, you're screwed. So that is something that you have to keep in mind, is that is very important. Ledger is your friend, make sure you have it. Rent fees and utilities, please don't commingle those, because that is very important to have a separate line item for everything that you put on. Partial payments create multiple application paths, and we're going to go through that in just 1 second. And then if your amount in the notice becomes disputable, that is how you lose your eviction in that 30 days right away. So let's see here. Your January rent was due for $1,000, balance $1,000. Late fee for January $150, $1,150. Water sewer $25.23, $11.75.23. Then February rent rolled in, and the guy pays or the gal pays on the 3rd of February $11.75.23. Well, the instinct is to apply it to here, right? Because that matches that amount. So that, see, they must have paid water, sewer, late fee, and January rent, because that's what that amount is as of 1/10. But you know what happened? We were already rolled into February. So February, we have a current month of rent that's due. So your first 1,000 goes to January rent because they did not pay that. And then 175.23 goes to your February rent. It doesn't go to any of the utilities or late fees. So you're trying to do a 10-day notice for February, and all of a sudden, you have just messed up. Because
doesn't it go to February rent first?
January, February.
But you receive the rent in February.
Correct. But the rent is due already because it's due on the 1st of the month.
So doesn't the $1,000 go to February first?
Right. No, because
It's the prior month's current, then all the other ones.
I think I was all wrong for years.
So it's
the current month.
90 to 20, or it's 90 to 20. Application of rent payments. Outstanding rent from prior rental periods. 2, rent for the current rental period. 3, utility and service charges. And only then, late rent payment charges, like if you have a late payment charge. And then only then is fees or charges owed by the tenant for like landlord expenses or fee charges related to damage claims or other claims under the tenant
That's why you come to these things.
So, and that is, because that is right there, it's 9220. So what happens is precisely that. If you were to give a February rent notice.
But wait, how is it that, well, so if you're evicting someone on the December rent and they come in with $2,000
Well, you're
in July, then
depends upon what you have on your notice. So if you're
10-day payment.
right, and say you had
Then you're done.
say you had $1,000 there, you're done, right?
Yeah.
And again, we're only talking about whether you're done or not. So this is only for that purposes. But yes, and the implication of payments will come into play because if you're receiving rent assistance, for example, or if some agency pays, like for example, the agency comes and they want to pay $11.75. So you receive that payment on the 3rd of February, and the agency obviously is paying you for that time. Well, guess what? You can apply that because that's not technically considered rent payment because it's not paid by the tenant. It's paid by the agency. So if the agency says we would like for you to apply it that way, some people argue that that's what you're supposed to do because it's not technically right. But we're going into the legal things here, and I'm trying to kind of stay away from that.
And I'm sorry, is
Yeah.
this pertain to every county in Oregon?
Yeah, this is statewide. This is a statute,
Okay, perfect.
right? Another way to lose an eviction is waiting too long to call a lawyer. So what happens in this situation is this. I want you to think of it this way. If things go sideways and you feel like something is wrong, it's easier to call a lawyer and find out quickly whether you did something right or wrong and whatever the cost is, versus having to go to trial and then the opposing party shows up with their lawyer and your case gets dismissed, and guess what happens then? There's a reciprocal attorney fee provision, so you then are responsible to pay the other party's attorney's fees. So this is what we're trying to avoid. We're trying to avoid having you dealing with that. And even sometimes in a situation where it's too late, you're still going to be exposed to attorney's fees. Having your own attorney will help you maybe negotiate down some of that fee. So there is always a way to work it out. But mainly for the future, talking to an attorney right away is the best way to make it happen and moving forward. So don't wait to save money, because that never works. If you wait to save money, that's a kind of a false hope. I will tell you this, I have seen situations where a very, very, very bad notice got filed on, again, by a real estate agent who was trying to help an owner to take care of the tenant. Miraculously, this got through to the first appearance. The attorney appeared for a defendant, missed the fact that the notice was horribly bad. They entered into an agreement and things resolved eventually for the landlord's favor. So can it happen? Sure. But would you rather to be in that position where you know that you're okay or not? I'm sure you would like to do that as opposed to thinking whether it's going to work or not. So yes, outliers happen, but in general, you're going to have somebody come, and if you have a bad notice or bad service, you're going to have problems. Remember, you cannot file until the notice expires. You file your case, then you discover a fatal defect. If it is already at that stage, maybe some things I can do is only basically a triage. I may not be able to help you, but I'll be able to minimize the damage. So the situation at this point becomes, what do I do then to minimize my losses? So I have seen very few situations where things are totally unfixable or become supremely expensive. And if your attorney tells you that this is unfixable, listen to your attorney and figure it out. Oftentimes the best way to do it is just kind of start from scratch. You dismiss the case, do it right, and go from there. Yes, you will have lost a couple months here and there of rent, but that's kind of more of a, it's better price to pay it that way than go for another, have the case dismissed with an attorney's fees payment, and then have to do the whole thing from scratch again. So taking proactive steps is always best. Late legal advice doesn't save money, it locks in losses. That pretty much says it all. So oftentimes people ask me, well, how much does it cost? Well, in the good old days, which I say never to use, before COVID, a normal defense counsel request for payment of fees on a bad notice was about $500. Right now, I have seen Oregon Law Center request for $4,000 on a bad notice, which means it was obvious on its face that the notice was bad, so there's really nothing for you to do. Instead, they come up with motions to dismiss, requests for admissions, requests for productions. Then they say we had to meet with our client 50,000 times, and then $4,000 later, you're still trying to fight it and call it, why is it reasonable that what could be done before with a simple phone call telling me, hey Rob, your client's notice is bad, how about $500? And I can say yes, now you are exposed to a lot more. So it's, again, outliers, but you're looking at some serious cost there. Okay, so what are we doing here again? Just a refresher. Even if you have a good notice, but a dead case, you even forgot to put a bad Portland notice, or you have used an outdated OJD, Oregon Judicial Department form, or something like that, a small impropriety can cost you the lost eviction. So what do the judges look for? And this is very important to understand in a sense that every judge, again, is its own kingdom. So they, again, have judicial requirements. They are sworn to uphold the law, but each judge has their own preferences. All of them will hold you to the standards that are required by the statute. If you think you can get away with that, you cannot do that. So if your lawyer tells you that you cannot take this notice to court and file on it and win on it, that's because it's just not going to happen, because it's statutorily impossible to win. Again, have I seen things happen? Again, yes, but if you are a risk taker, I guess it's up to you, but the point here is to prevent that risk from happening. So that would be something for you to take a look at.
Well, dear God, time.
Skip that. And let's talk quickly about AI, and then we're getting close to the end. So this is a hot topic nowadays. I wanted to give you an actual example that I ran with ChatGPT. So I asked ChatGPT, please tell me what statute tells me to attach this OJD rental assistance eviction help notice. Okay. So ChatGPT in blue comes up and says RS 9394-2-C requires that blah blah blah. It doesn't. There is no such section. It does not exist. So I tell the ChatGPT, I said, you're wrong. The statute requiring such notice is RS 93952 and RS 105136. Good old ChatGPT comes back and says, yeah, you're correct. This is explicitly tied to this and this and this section. So the question that I have is then why the heck did you give me the wrong statute when I asked you that? So AI has not come up there yet. If you are relying on AI to do your legal work, please don't do that. Maybe later it's going to change, but not yet. I found Grok to be a bit more human-like and a little bit more responsive, but they still have all these limitations. It's what I would call this, basically it's a hallucination. They come with these things that they feel like they want to tell you what you want to know, but it's wrong. And if you do that, you're going to be in trouble. Another example, there is a law platform which is called, there's two of them actually. One is Westlaw, but I use LexisNexis. And all they do, and this is their thing, they collect law from every jurisdiction in the whole entire country, and that's all their database has, is law. I put in a prompt, I ask it to do some search, and it comes up with the most cockamamie answers. And I'm talking about this is purely based on law itself. Like, how could you mess it up? And they do. It comes up with something, it cites to cases that either don't exist or exist with like little tiny minutia written in the footnote. Well, that's not law, that's just maybe judges trying to explain something that is not really applicable. You cannot use it in court, but it still happens. And if that platform that does nothing but law can create mistakes, I mean, ChatGPT, there's no hope there. So my suggestion to you, if you're trying to run your cases and trying to get some answers through ChatGPT or some other platforms, they're not ready yet. Beware. You can do it, you can get general information, you can get general ideas, kind of, sets you on the right path, but you still have to do your own research, you still have to double check it. They are not ready yet.
I will second that. I've looked up City of Portland law.
Oh, that's the worst.
I've looked up
Yes.
state law. It's really, really bad.
Yeah.
But if you're looking for a way to create a settlement,
Correct.
like ways to, amicably resolve the situation, ChatGPT is great.
Right. So, and ChatGPT is very good for communication with tenants too. It sanitizes it and makes it nice and professional,
Absolutely.
and it's perfect. So that one, I use it myself too. But anything short of actual law research, no. Finishing up, realtor-specific points. Please make sure that as a realtor, you're helping your client you're not trying to sabotage them. I understand you want your commissions, but remember you have an obligation. You have an obligation to them to help them because you're their agent. So it's unstructured cash for keys. That is the newest thing that is happening. Everybody wants to do cash for keys without understanding how it works, and it's actually a contract that you have to write up, and it's always best to have it in writing, because if you don't, what are you going to do about it? A lot of things that I've seen right now is encouraging action before legal review. Again, remember, you are an agent. You are going to be infinitely more helpful if you help your client to get legal help if there is an issue. But if you're trying to do it yourself, you're running into problems. So, how do we do this? To place the safe playbook, pause before issuing notice, confirm jurisdiction-specific rules, don't freelance eviction strategy, assume everything becomes evidence, and get legal input before filing. If you develop a system like that, you should always be in good shape. There we go. Evictions rarely fail because landlords are malicious. They failed the first 30 days because they were just handled casually. If you make a mistake, you're not there, it's not the end of the world. You're not there to suffer. You're there to get help, and help is available. You can choose whatever lawyer you want, but remember, they're there to help you move things forward. You're there to help your owners, you're there to help yourself, to make money, not lose money. Final thoughts?
So if you've got a tenant who is 6 months past due,
Yes.
should you file a 10-day notice or should you file a 30-day notice?
It depends upon how much extra stuff they have. If the tenant, if the amount of rent per month is high enough, like it's 2000s or higher, I would just do a 10-day, but you have to be careful with those obligation of payments. So you have to be really, really, really precise that you do not have any months that you're trying to file for that is a partial payment. Because the chances of them coming up with that amount are very low.
So you mentioned earlier that applications of rent. So if you file on, like, let's say that they're 3 months past due, it's 2,000 a month. You're filing
on 3,000.
You know, and it
right.
And so we're filing for May. They haven't paid in April or March.
Sure.
So you file for May. But if they come with $2,000 to court, that applies to March.
That applies to, you take it, you dismiss the case, but then you apply it according to the statute to whatever month was left.
But you dismiss the case?
You dismiss the case. You have to.
You have to dismiss the case even though that they didn't cure the notice.
Well, if they cure the notice, because remember, your hypothetical was, it's a $2,000 notice amount.
Yes.
They bring you $2,000. They cure the notice.
$2,000 for May.
That doesn't matter. What matters is the amount of the notice. Okay. So if that's why I'm saying that 10 days are good when you have a lot, because the chances of them paying it off are very small. I usually go with a 30-day because then you can throw everything in the kitchen sink.
You give them 30-day notice, and you get to give them notice for all the past rent.
Right,
all
everything. Yes, unpaid utilities, whatever. Right.
We had a tenant in Washington County who was, I think, 7 months past due.
Yeah.
And and we filed on time. Like we did everything perfectly. And then he came in with 1 month's rent, and then it took us another 7 months to evict him.
Right.
He basically.
So that's what I'm saying. We have to be very careful with 10 days.
The danger of the 10-day notice.
And had you done the 30, you could have. He would have had to come in the 70.
Correct. But if you done the 30, you wouldn't have, because they still owe you rent through the time, and then there's a way you can take partial payments on 30s, but you cannot do that on 10s.
But it's so like shocking
Yes,
that the statute
correct.
states
Yes,
that
absolutely
it
right.
goes to a prior month, but if you file notice for a certain month,
It doesn't matter at that point. It matters with the amount on that notice. So if the
Why
notice
can't you
amount.
file a notice for the whole 7 months that you haven't paid?
Sure.
that's a 30-day notice.
Well, no, but you can do a 10-day notice for 7 months if you want to, but that's what I'm saying, that they have a much better chance of success.
But wait, you can do a 10-day notice for
Why wouldn't you?
all of the.
So long as it's in increments of the exact amount, so there's no partial payments. But like I said, I prefer just to have the 30 for everything. Why would
It's
you
gonna
not do
take
that?
6 months anyway. You might
Right,
wait
well,
the
may as
extra
well
20
put the late
have
fees
more
and everything
protection.
else in there, right? Making the amounts higher. Because your goal is to play the game that the legislature wants you to play. And the game they want you to play is take the notice amount before entry of judgment on a 10-day notice. So if you don't want to play that game, you go the 30-day route, and then you throw everything in there and make it more difficult for them to pay that amount. Otherwise, you're going to just do it over and over again. So this is one thing that you may have seen. I think it's not KDU, Channel 12, Fox just came up with a new thing where they had a shocking statistic that so many more evictions are being refiled again. Well, that's the legislature's creation because they caused it to happen, because if you have to dismiss the case on a payment, you will then refile because the tenant will still be behind in rent. So instead of one eviction you have 2. And sometimes it's 3, and sometimes it's 4. Because, some owners want to do it steadily and they have a policy that 1 month you're out, basically. 10 days goes out the door, which is fine. But that's what happens. So instead of, 1 eviction, in the record now there's 4, and they're like, oh my God, everything is the quadrupled, the eviction numbers are so through the roof. This must be a terrible crisis. Well, yeah, you created it. So that's where we are. Any other questions? Because I need to be respectful of your time, guys. I know we're already over. So, remember, it's all fixable. You're winners. Make it happen. Understand the pitfalls. If you do it well, there you go. But if you don't do it well, you can still get it done, fix it up, and move forward. Thank you so much. I really appreciate it. For the opportunity. You've done a great job. Everything is fantastic. I'm very impressed. And thank you. My cards are floating around if you want.
Yeah, their cards are out and about, yes. Thank you all for hanging out. We're going to be here for a while if you want to sit and mingle. I'm constantly up here. I opened up more bottles of wine. There's a few more snacks and crackers and food if you want to just spend some time with us. Yeah, I'll be here, but I think lots of information, great information.
Thank you.
Yeah. I need a certificate after this. Yeah, but basically.